Good morning, Matt. Can you hear me okay?
Yes, I can hear you.
Okay, just checking. I had a couple other hearings earlier in the week, and I was having some difficulty with that. So good. So far, so good.
However, I cannot hear the court.
No, I saw Judge Munch on the bench, but I don't see him now at all. I just looks like I'm looking into the back of the courtroom. It looked like he was waiting for something. I don't know.
I can see Judge Munch on the bench. I can also see the courtroom view, but I can't hear the judge or anything other than you.
Okay. Was it Wednesday they had a power outage in the middle of a very busy dock? I don't know if they got that fixed or not. Good morning, Eric. Can you hear me okay? It's Scott. That sounds like a no.
Scott, I think he's muted.
Yes, I can hear you.
You can hear. Okay, thank you.
There we go. Yeah. Yes.
Can any of, if any of you can hear me, would you wave your hand, please? We're having a lot. Okay, it looks like we have everybody at this stage again. Okay, we're on the record. I have I'm afraid closed out the screen that I had the case numbers on. Counsel, would you please enter your appearances and indicate the case or cases that you're appearing on here today? Why don't we start with the prosecutors?
Yes, Barbara, for the people, I'm appearing on all three misdemeanor cases this morning: 19M4727, 19M4726, 19M2054.
And Mr. Poland, you're entering on those same misdemeanor cases, aren't you?
That is correct, Your Honor. Mr. Brandt appears to be appearing over at the jail in the facility that they have there by video.
That's right.
And for the
All right,
record,
and let's
this
hear
is Mr. Brandt, I am here, yes.
And
Let's hear now from. Go ahead.
Judge Matt Kelland appearing for Mr. Brandt on case 20 CR 358.
All right.
Chad Greenblatt for the people.
All right, and Ms. Paul and I, or Mr. Brandt, I take it you can hear me. I wanted to make sure that you can hear. Can you hear all the lawyers as well?
Yeah, affirmative, Your Honor, yes.
Okay, okay. At this point, I haven't muted anybody because I think you've all done this before, and if somebody wants to talk, usually they'll sort of wave at me so we can make sure that we get their attention. It seems to me we got a couple of things we want to get accomplished today. First, you're all going to brief me on what's going on in terms of all of Mr. Brandt's other cases, so we can take that into consideration in deciding what we're going to do on these cases. Secondly, we'll figure out what we're going to do in terms of future dates on these cases, and then we're also going to take up the question of bond, which I indicated we would take up here today. Why don't we start? Let me ask Ms. Kelly, can you tell me what's going on in terms of your efforts to get all the lawyers on the same page here? Sure. Just 1 second. One of the DAs wanted to ask me to. I have plugged it into this. If this will work in any of the holes. Guys, wait a second. It looks like I'm supposed to. Is this what we're supposed to do?
Yeah.
It doesn't look like it's in any of the. The problem is it's not getting recorded where?
So the audio output is only coming through the speakers on your computer. So if Helen or Mr. Poland or Mr. Brandt is talking, we won't be able to hear it out here. So there is a workaround. If I can just figure out.
Yeah, I'm sure there. Yeah, there is. Here's what we need to do. I just need to put this to wherever the speaker output is on my computer, which is what I think is up here. All right, counsel. I'm sorry. We have an issue in the sense that my computer is so old that it isn't compatible with the new system, and the result is for the people in the courtroom to hear you all, I have to try to put the microphone in the courtroom right next to the speaker on my computer. And I want to check now and first see if we have done that. So, Mr. Poland, would you just, talk for a couple minutes, spout some numbers, or recite the Declaration of Independence or something, so we can see if you can be heard?
Sure, Judge. It's my understanding we're all looking forward to some beautiful weather this weekend.
Very good. Thank you.
Could you hear that? Okay.
Yeah, they can hear you all right. Scum, would you give it a try, please?
This is a sound check.
Yeah, and they nodded. They can hear you. Mr. Brandt, would you do the same thing? Just say anything at all?
Your Honor, I would actually like to recite the entire Declaration of Independence, if that's okay.
No, I think they actually heard you, so we're okay at that point. All right. Now, where we were was I was going to ask Mr. Cullen or the prosecutors to let me know where you all are in terms of communicating with the various lawyers in the various jurisdictions to see whether or not I should be taking into consideration possible dispositions in other cases. So I don't know who wants to go first on this.
Your Honor, I can address that.
All right.
So first, Your Honor, the other felony case in Adams, that was case 20 CR 19. We were in court on that case last Friday. Bond in that case was reduced to $3,000 cash only. There has been no offer yet conveyed to Mr. Brandt involving either of his Adam County cases, and I also believe that Denver and Arapahoe cases are still in that same area, although I'm not on any of those. I can tell the court that Mr. Greenblatt had extended an offer to Mr. Brandt this past week, which included just the Jefferson County cases. We had informed the district attorney that at this time, we are not going to be accepting that offer. We are attempting to find an offer that will include all of the other cases as well. At this point, it's unclear if that is something that the district attorney is going to be receptive to. I think primarily the concern there is the timing and the trial that's set to begin in slightly over a month. We have some more information as far as that goes, Your Honor, but I don't think that that's what the court's asking at this point.
How about the deferred judgment? Have they set that case for sentencing yet?
No, they have not, Judge. The senior judge in Adams County has continued that case to was this July 24th, along with the 20 CR 19 case. Those have both been continued until July 24th. We had explained to the court in Adams the same thing we've told this court, that we are attempting to find some sort of a global resolution, including all of the counties. So they set that over for an opportunity for the defense to try to put that together. I do understand that at least Jefferson, Adams, and Denver County district attorneys have been in communication, although as far as I'm aware, no offers have come out of that communication other than the Jefferson County global offer that was made to Mr. Brandt this week.
Which only relates to the Jefferson County cases.
That is correct, Judge.
Well, okay, obviously I'm not going to ask you what you've answered the question that I had, and if I'm hearing you right, it sounds to me like what you're telling me is that you won't know for certain one way or the other until, what was it, the 24th of July, because that's sort of the date on which your client will either be sentenced or get a sentencing date in Adams County, and that will kind of be driving the rest of the show.
Well, not necessarily, Judge. There has not been, although we are exploring the possibility of resolving these cases, as we sit here right now, no offer has been made in those Adams County cases. So I don't want to leave the court with the impression, at least right now, that we anticipate resolving those on the 24th. I think that's more of a check-in date.
All right. Now this is, I don't have a dog in this fight, but you all are aware that at this stage of the game, at least if I'm reading the law right, or the fairly recent case right, Mr. Brandt is only getting day for day on the time he's spending in jail, awaiting his sentencing on the revocation of his case in Adams County. He's not getting any good time or earned time or anything like that on that, and I don't think he can until he gets sentenced. But I take it there are a lot of factors to take into consideration, and he's okay with having his sentencing continued like that?
Well, and Judge, as I said, there is no sentencing set, not even in the deferred case.
Okay.
And Your Honor, I see that Mr. Brandt appears to have his hand up. I think he wants to address the court.
Well, I'm going to get to him in just a second. I just want to make sure prosecutions, you have anything to add on this that in terms of the communications among everybody? Yeah.
What I can tell the court is that Mr. Kellen and I have had conversations. They made a request of us for a potential resolution. We actually extended an offer in line with that request.
But it only relates to the Jefferson County.
Correct. That is accurate. While there has been communication with the other jurisdictions, there's been no global offer.
Mr. Brandt, it looks to me like you want to be weighing in on this too.
Thank you, Your Honor. To be quite specific, Judge Plansky in Adams County set the revocation case as a personal recognizance bond. And he specifically asked, in the interest of engendering and espousing the possible global agreement disposition, that so he set that to follow the current cases. And that date was set. Next date was set for that based on the prosecution's representation. The people represented
All right,
that they
I
felt
have
they
to
would need
interrupt.
at
I'm
least that
having a
much
lot
time.
of trouble hearing Mr. Brand.
I'm having a little trouble hearing him too. Hold on, Mr. Brandt, just a second. We're having a little audio trouble, and our deputy is calling the sheriff to ask him to see if they can make you a little louder.
Okay, that's never happened before.
Well done. Yeah. Would you move a little closer to the microphone if you would?
I'm presuming the microphone may be in the device. Maybe I'll move it closer.
That's fine. Now,
Is this clearer?
Yeah, I think that's a little bit better. Let me try to repeat for these folks what I think you just told me, and you correct me if I'm wrong.
Yes, sir.
What you said was that you've been given a PR bond on the deferred judgment,
Correct.
and the judge on the deferred judgment said that he was going to wait on your sentencing until there had been a resolution or at least further progress on the new Adams County case. And therefore, we put them both together on this date in July. Did I hear you right?
So the date of July, as Mr. Kellen represented, was more of a check-in date, and that was because the prosecuting attorney, actually told the court that they felt that they needed that much time. I know that this court is working on a double death penalty case where there are thousands of pages of discovery, so I'm sure that you can empathize with multiple jurisdictions. There's actually not just thousands of pages of documents in this case, but in these cases, I should say, but there's also literally thousands of hours of video that has to be gone through. So that prosecution team and that court realized that and set that date out. She said that they thought they would need at least until July 24th to be able to make a resolution. I will also represent to the court that the Denver court set exactly the same date. So we'll have a little bit of a conflict there to resolve, but the other two jurisdictions are clearly aware of the challenge here. And that was one of the reasons why I was so confused at our last hearing when I had said, no, I thought we were continuing this out. And I expressly stated I didn't want to start any timers. And I want to apologize on behalf of Mr. Kellen to Mr. Greenblatt, because I think Mr. Greenblatt and other jurisdictions have expressed that they have a desire to reach an agreement. But by starting those timers, which I had expressed concern about, I think that it placed him and Mr. Kellen into an artificial deadline where they felt that they had to do something now. And really, I thought the purpose of today's hearing was more directed at possible bond reduction to engender the kind of global resolution that's been made possible. I won't say it's necessarily available because the veterans system is shut down right now, but I was really concerned about starting that timer, if you'll recall. That was nearly a month ago. I don't think that we were able to be fair to either party, and I don't want Mr. Greenblatt to think that he has to prepare for a trial. Because he said that I've got to know today, and I was just told that 2 days ago, and that's not fair to me either. I don't want Mr. Greenblatt to prepare for a trial. I think the prospect of the Veterans Court putting me through law school is a very big carrot and a very heavy cart that I'm willing to tow a very long way. And I know the court's not involved in the negotiations, but I'm going to ask the court to engender the negotiations, and I'm going to ask Mr. Greenblatt to accept my apology on perhaps imposing an artificial deadline. And my lawyer is going to tell you that I'm willing to toll speedy trial as long as necessary to engender that.
Right. Now, Mr. Brandt, your sentencing on the misdemeanor, the Jefferson County misdemeanor that you were convicted of, that has been postponed from, I believe, someday in March, and you told me we didn't even want to reset it until today. You have the right to be promptly sentenced once you've been convicted. I'll go ahead and set a sentencing date on that, but if I'm hearing you right, it sounds like you're saying you want it to be your sentencing date to be pushed out into the future a ways, but I don't know. Do you want me to sentence you promptly, or do you want me to postpone your sentencing again for a couple of months?
Your Honor, you know, and I agree with that. I appreciate the court had made the representation that he'd be entering a sentence.
You're moving away from the microphone now.
Sorry, the court had indicated, and I appreciate that the court would be entering a sentence in that case, nunc pro tunc, and based on that, by the law, I think that I've pretty much almost served the maximum sentence, and I appreciate the court making a record on that, but also understanding that we will be appealing that case without any question. So I have no objection to setting the sentencing out another couple of months. I've already been serving quite a bit of that time. And I think that as this other process comes forward, I think the court will see a lot of mitigating factors. I think that case is pretty clear that it was a case of police wanting to silence a prominent vocal critic.
Well, I don't want to just know whether you have no objection to it. My default position would be, yeah. Are you affirmatively wanting me to do that?
I am affirmatively asking the court to do that.
Okay, that's fair enough. That's fair enough. Okay, then regarding the other two Jefferson County misdemeanors, we've had waivers of speedy trial on that, and candidly, the impression that I get is that you know, they're not what's driving this show anyway. But at least one of them, even if they're not victims' rights cases, at least one of them has victims' right implications. So I want to find out from the prosecution, have you been in consult? It sounds to me like you're all going to ask me to continue these misdemeanors again without setting a trial on them. Before I do that, I want to make sure that not only the defense wants that, not only the prosecution does, but the victims have at least been consulted about it and are not objecting to us doing that. So
I was set to talk to the victim today after we decided sort of what was happening in these cases. Since today was just a status, I wasn't clear if we were going to set a trial, so we're kind of in the waiting period.
Well, so you can't give me any information on how they feel about continuing to delay this?
Your Honor, I'm having a lot of trouble hearing her. I apologize.
What she indicated to me is that she hadn't actually discussed this question with either the police officers or the victim of the other case. She's going to talk to them today. She sort of informed them that this could be a long process because people were thinking of a global disposition, but she hasn't actually asked them how they feel about this, so she can't give me that info.
All right, thank you for that, Judge.
She just said one other thing and I didn't catch it.
I am happy to go outside and make that call right now and see if
Well, I might ask you to do that in a little bit, but not quite yet. Okay, so here's where I think we stand. Regarding the Jefferson County felony case, I'm going to go ahead and set a motions hearing date and a dispositional cutoff date and a trial date. But the impression I get from all of you is, frankly, you'd like to have some time on that. You'd like it if I don't set that terribly promptly, maybe set it out till September, or I suppose possibly, well, let's see, possibly in the very beginning of October. It's usually not my tendency to want to let things drag out like that, but I'll probably do that. I think you've got good reasons, both because of the coronavirus and because of the issues that you're having getting everybody on the same page. But I'm not going to just let this thing be in limbo anymore. We'll go ahead, we'll set a motions date, we'll set a dispo cutoff date, we'll set a trial date, but I will do what I can to be accommodating to you by having this go out a ways to see if you can continue to make some progress.
Because resetting and making trial date is Mr. Brandt's request, I am objecting to that. However, if there's a waiver, I'm not necessarily objecting to it, but I think that necessitates a waiver in speedy trial.
Oh, sure. Mr. Brandt already indicated he said he'd be happy to waive. He'd like things postponed as long as they can.
Well, as a matter of fact, on the toll, I'm asking that there be an actual waiver.
Well, we'll get to that, but assuming that's the case. Okay. Ms. Kellen, you wanted to say something now?
Yes, Judge, thank you. And specifically on that issue, Mr. Brandt and I discussed this specific scenario and talked about dates. Mr. Brandt's request would be to toll speedy trial and restart that timer at the motions hearing. The date that we had initially talked about when neither of us were looking at a calendar was August 1st, which I believe is a Saturday. So I think that August 3rd would be the closest realistic date to what Mr. Brandt and I had discussed. After running the time computation, Judge, it actually looks like whether we were to, if the court was to grant that early August 3rd date that we were requesting, under either scenario, if the court were to toll speedy, which was Mr. Brandt's request, or if the court was to require a waiver of speedy trial, it appears that the time would pretty much fall in the same range, which would be right around the beginning of December, around December 3rd. Under either circumstance, maybe give or take a few days. So that was something that I have not been able to discuss with Mr. Brandt when we had that initial conversation. And I know that he wants to address that. But realistically, for the court and for Mr. Brandt, I think the dates turn out to be the same, whether it's a tolling of speedy or whether it's a waiver of speedy.
Well, let me be clear. I'm not going to require anybody to waive speedy trial, but I'm not going to toll it. I mean, either we'll set a trial date that is at least a month and a half before speedy trial expires, or it'll be waived. But it is not appropriate in a circumstance like this just to toll it. I mean, this isn't a competency question or something like that. So, but that's neither here nor there. And I may have misunderstood Mr. Brandt. I thought Mr. Brandt was indicating he didn't have an objection, and indeed seemed like he wanted to waive speedy trial and get things moving. But I'm well in this area. So, Mr. Brandt, let's see, Mr. Brandt,
yes,
can you get close to the microphone again.
Yeah.
Your lawyers indicated to me that he told you that because this isn't the kind of thing where we usually toll speedy trial, that probably wasn't going to be on the table, but he indicated to me that would be your preference.
Well, I'll let the court know what my thought process was on that. First
Sure.
of all, I think that Mr. Greenblatt has expressed a genuine interest in resolving these cases, and I don't think that he can do that fairly to the people or to me if we just have this deadline. So I think that he was kind of pressured. My lawyer expressed an interest in resolving, kind of to see where they were thinking, and I think that he felt pressured. And these cases on first blush might appear to be not worthy of the people's time, but I think that particularly considering what's going on in the nation right now, that actually these are substantial questions. And there is work that should be done. I don't want Mr. Greenblatt to prepare for a trial. I think that it's very obvious that the noose is very tightly around my neck and that I'm standing in a chair right now. And so I don't want him to go to trial. I want to resolve them, but I want to resolve them in the right way that's fair to both parties. We're fair to all parties. I think that it's pretty obvious with the public interest that there's more than just two parties here. So my offer to toll speedy trial until motions hearing was an olive branch to Mr. Greenblatt and to the court to say that, hey, I don't want a deadline, a statutory deadline, to be driving the process of negotiation. I want the process of negotiation to be geared and driven by justice and the time that it requires.
Well, I appreciate your motivation, but ultimately it boils down to the question of, do you want to waive your statutory right to a speedy trial and have the 6 months start all over again or not?
Absolutely.
Okay. I know we've been through this before, but it's sort of a ritual we have to do every time. You have a right to a speedy trial under the United States Constitution, under the Constitution of the state of Colorado, and also under the state laws of the state of Colorado. And there's no set time limit on the Constitution right, but there is on the state right. And that is 6 months from the time that you either enter a plea of not guilty or waived your right to a speedy trial. You have the right to be tried within 6 months of that time. And if you waive or give up you're late to a speedy trial? Well, first, you wouldn't be able to complain that your federal or state constitutional rights have been violated because you're the one that asked for the delay. But beyond that, the 6 months under the statutory right would start all over again. Now, are you sure you understand all that?
Your Honor, I'm a constitutionalist, and the speedy trial provision is also mentioned in our Declaration of Independence, and the function of that was primarily to not whisk people away to England and drop them into an oubliette forever. I don't think that's going to happen here. If anything, I'm already in the oubliette. So I fully understand that, and I absolutely desire to waive it. I'm more interested in justice, and I'm not afraid of being whisked away to an oubliette.
All right, well, the waiver will be accepted. In light of that, it appears to me that it is Mr. Brandt's desire, and I think his attorney's desire, that I give you as long as I think is reasonable, so that you all don't have to start, gearing up for trial until the possibility of a resolution has really been resolved. And as you know, those of you that know me, it goes against my nature to have these things significantly delayed, but I don't think in this case it's unreasonable. So, counsel, my inclination will be to set this matter, the Jefferson County felony matter, for trial sometime in late September or early October. Could you all look at your calendars for that time frame and tell me how you look for, let's say, the 6th or 13th of October to start with? One second, yeah.
May not be. Jesse can connect you, so it'll come through there.
Yeah, we have an absolute computer guru who came in, and he's going to try and make sure we're connected appropriately.
And Your Honor, while that's going on, I have either the week of the 6th or the week of the 13th of October.
Access code or meeting number.
1 second.
Followed by pound.
We're waiting for our guru to get us set up here.
Am I going to audio?
No, here, go ahead, one.
Your entry is not valid when a meeting.
So we won't need that anymore?
It should come through. You have to make sure everybody can hear.
Okay. Council, let's hope we resolve these matters. Again, we need to do an audio check. Mr. Brandt, would you just say anything at all?
Shall I start with "We the People"?
You got it. We can hear you just fine. Mr. Poland?
Yes, Judge.
Okay, Ms. Kellen?
Yes, Judge. Could we also have an audio check from the district attorney? I'm having difficulties hearing anything that's coming from that table.
All right, would each of you?
Hello, Mr. Kellen. Good morning.
Did you hear anything there?
Yes, that was much better.
Good morning.
Yes, much better. Thank you.
Okay. Thank you very much. Now, I think you were telling, you started by telling me that you could make those two, either of those weeks work, but after that we had some feedback from.
Sure, Judge. What I was saying is currently October 6th and October 13th, those entire weeks are clear on my calendar.
All right. How are they, the prosecutors?
October 6th, I can do. October 13th, I cannot.
All right. I would assume this is probably either a 2 or 3 day trial, but I'm kind of inclined to set you on a Tuesday anyway, just in case it goes longer. So how about October 6th? That works for everybody, right?
Yes, Judge.
I agree with the court. 3 days would be more appropriate.
All right. Then we will set the matter for trial on 10/3/20 at 8 o'clock. We won't actually get the jury up here till probably 8:30 or even 9, but we'll all be here at 8 in case there are any last minute matters we have to deal with. Now,
Your Honor, I'm sorry. One other request from the defense. I know that that's certainly a number of months out. I'm not sure how Likely it is that all of the health concerns around COVID will be abated by October, specifically as it relates to being able to convene a jury. I don't know how things are going to play out before a vaccine is readily available to the general public. I think it may be prudent to set a date, perhaps 2 weeks or so prior to that jury trial, to have a true pretrial readiness conference and allow both sides to make any arguments and sort of address where the public safety concerns as far as convening a jury in an enclosed room like that, where we are at as a jurisdiction at that point.
I don't think that's a particularly bad idea. I also want to set a motions hearing date and a plea cutoff date. And yeah, I would not anticipate that the motions hearing date that we would require an awful lot of time, or that there would be that much in the way of evidentiary motions. But you all have done the discovery, and you know better than I do. I'm trying to set about 2 hours for motions. And since I don't think you're going to have significant evidentiary questions, I'd be inclined to do that sometime in early or mid-September. But I'd like your input on whether I'm seeing it right.
Your Honor, based on my experience with these kinds of cases, I would suggest that there's a high likelihood of testimonial motions hearing.
And Judge, I think perhaps setting an afternoon might be prudent. If we don't need all the time, that's fine. But I think it might make sense to schedule more time than we normally would for a case such as this.
Counsel, can you tell me what kind of evidentiary motions you think there might be? Your client thinks there might be evidentiary motions, and I'm having trouble figuring out what they could be.
I know certainly the district attorney has filed those 404B motions.
Oh, yeah.
And, they relate, and I apologize, I don't have it right in front of me. I know it relates to the current Adams County case. And in full transparency, Mr. Brandt has been charged with similar offenses in other jurisdictions, even since he's been in custody on this case. I don't know what the DA's...
Not since I've been in custody here.
I think so. The Arapahoe and either way, Judge, there are at least the Adams County case that I know has been filed as 404B. I don't know if there will be any more than that, but I think a little extra time on these cases would be prudent.
No, well, it's not. I'm not asking you because I'm concerned about the difference between 2 hours versus half a day. I'm asking you because sometimes when you have evidentiary motions, you need to put in a little bit of time between the motions hearing and the trial so that the lawyers have time to. But that would usually be when there are suppression motions or things like that. And it seems to me that I mean, there may be evidence on 404B, but honestly, it seems to me that wasn't my biggest concern here. But the bottom line is the request is we do half a day. I think that's a reasonable request. But none of you think you're going to need more than 2 or at most 3 weeks between the motions hearing and the trial, right?
Your Honor, typically I request 4 weeks between motions hearing and trial. That way there's time to get a transcript without incurring expedited costs. Mr. Brandt is an indigent defendant. He's being represented on this case by alternative defense counsel. And certainly, if it's possible, we would request 4 weeks so that if a transcript is needed, one can be requested without the state incurring unnecessary costs.
Sure. If there was that much, if we hear from witnesses, it might be testifying again at the trial, right?
Correct, Judge.
Yeah. Okay. I don't think that's very likely, but it's not an unreasonable request. So we'll take a look at I don't know what is September 17th.
But
either the 10th, 11th, or the 17th. How do those look for?
I'm in a 3-week trial during that time period.
When does it end?
It is set to begin September 8th and run for 3 weeks. So if I can accept a date, either September 1st, 2nd, 3rd, or 4th, or I would be requesting the last week in August.
And Judge, currently my calendar is clear for that first week in September.
All right, we'll do that. We'll make it September 4th then. I think that's most convenient for the court probably because they may be swamped then depending on what's going on. And I get the impression you all would prefer the afternoon?
I'll defer to the district attorney on that request, Your Honor.
I don't care one way or the other.
Whatever is best for the court.
Well, I think if it's up to us, we'll make it at 8:30 in the morning, I think, if that works for y'all. So 8:30 on September the 4th. Right. Now we'll set a dispositional cutoff date just a few days before that because I don't think there's going to be a lot of preparation necessary in terms of motions. What I don't want to do, what I'm not inclined to do is to have everybody have to do an awful lot of work to prepare for motions only to find out that work was in vain because you got a deal. But the motions here don't seem to be that, I don't think that is a particularly heavy burden on the lawyers. So I think I'll just set your dispositional cutoff date, let's say Monday of that week. How about August that's the 31st, isn't it? We'll make August 31st the dispositional cutoff date.
And Your Honor, just for the record, I typically request dispositional cutoffs to occur after the motions hearing. I certainly understand the court's reasoning on that. However, if there are any rulings that come out of that motions hearing that were to change the posture of the case for either party, at that point, I think it might be appropriate for a different disposition that might have been contemplated prior to the motions hearing.
Well, I understand your position, and it's not, but and again, let me just tell you, my understanding of the law is when you impose a dispositional cutoff date, what a judge must do is if there are significant change circumstances, you at least have to listen to the lawyers as a reason that they should be able to get have you consider a disposition despite that. So you're right. If something comes up and good cause is shown, then I'll take another look at it. I think that's what is required under the law anyway. But basically what I do is my protocol assumes normality and I make exceptions for exceptional cases, but I don't modify the protocol for the exceptional case. What we do is we look at the reasons to make it exceptional. So your objection or your position is noted, and if it's an objection, the objection is noted. But the dispositional cutoff date will be the 31st of August at the end of the day, and when that date comes, if that date comes and goes, I would ordinarily accept either a plea to the highest substantive charge or a dismissal of the case entirely, or I would require good cause to be shown to consider any other kind of a disposition.
And Your Honor, I'm sorry, Your Honor, just for clarification, if the defense and prosecution is able to reach a disposition by August 31st, would the court, if notified by the end of the day on August 31st, would the court then allow that disposition to be entered on the currently scheduled motions hearing date?
That's exactly what we would do, but we would also understand that we're not talking about a half a day. We're talking about, a plea. We're talking about half an hour.
Yes.
It helps a lot in terms of scheduling the court's time. But no, you wouldn't have to come in on the 31st. You'd come in on, you would let the staff know no later than the end of the day on the 31st that you have a firm disposition, and the result is what we do would be take your plea on the motions hearing date. But nobody would be in a position where they have to subpoena witnesses or they have to put themselves or anybody else to significant inconvenience because we know we were going to be taking a plea then. All right. Now, you also requested that we do some sort of basically a status conference, which I don't generally do, but I think under the COVID circumstances, that's not a bad idea. And you wanted that to be maybe a week and a half, 2 weeks before the trial. Is that what you said?
Yeah, Judge, and my thought with that timing is far enough ahead that it's realistic that the parties won't have to. The parties would at least be able to call off any subpoenas that are set for the jury trial date if it's not going to happen. And I don't think there's a reason to unnecessarily summons jurors if that's not feasible at that time.
It's a perfectly reasonable request. And I think the commissioner likes to have about 2 weeks, and I think that's what you all would like to have too. So let's look. Well, the trouble that puts you right in the middle of the DA's conference and the public defender's conference too. Then
For that type of status, if the court is willing to entertain WebEx appearance for that type of status,
sure, of course.
We can accept the 18th, September 18th. I believe that that would be sufficient time for the jury commissioner.
Well, for some reason, September 18th is marked out on this calendar, and I'm not sure why that is. All right. How's September 18th then?
I can accept that date for the defense judge.
All right. September 18th.
Can we do that at 9 a.m.?
At 9 o'clock. And that will just be a, what do you call it, a trial readiness conference or something like that? I think that's a good idea. All right. Now, regarding the felony case, I think we've got the dates that we need. I think that the defendant's request basically that we not do anything. I'm not going to do that, but I am appreciative of the desire of the defendant to make sure that people in all the jurisdictions have time to get together and see whether something realistically can be done. So hopefully that will give everybody plenty of time to accomplish that goal if that goal can be accomplished. But if not, we'll have a trial that will start on the 3rd of October. Now,
Thank you, Your Honor. I appreciate that.
all right, now regarding the misdemeanors, I'm sorry, I said the 3rd. That's not right. It's the 6th of October. Seems how the 3rd
Yes,
of
I have the
October
6th.
middle of the October 6th. We're not going to start it on the weekend. All right. Now, regarding the misdemeanors, while don't anybody ever quote me that I did this, I'm going to go ahead along with what I think is just the request of all of you. And unless there is objection from the victims, which we'll find out about here in a few minutes after the DA makes a phone call, I will go ahead and basically continue the arraignment on those misdemeanor cases with a waiver of speedy trial until we're all here again on September the 4th. That is pretty unusual, but I think there are rational reasons for it. However, I'm going to take into consideration the position of the victims, and if they object to that, then I will bring you all back here in a couple of weeks and we'll go ahead and set trials on those. But assuming that the district attorney is able to report to me that the victims do not object, I will accept a waiver of speedy trial on the misdemeanor offenses and set them over for purposes of arraignment until September the 4th.
Your Honor,
Okay, now,
fully
Mr.
incorporating the record from before regarding waivers of speedy trial, I expressed to the court that I am in complete agreement and fully waive my speedy trial rights on those 2 cases.
That's exactly where we were going, and I accept that you understand those rights, and we don't have to go through that again.
Thank you.
All right, now, Mr. Poland, other than getting to the issue of the bond motion, let me just ask all of you in turn whether there are any other issues that you all wanted to take up today. Mr. Poland, you're on these misdemeanor cases. First, did Mr. Brandt accurately set forth the position of the defense that you would like these things continued and not to have new dates set if the court was willing to accommodate that?
Your Honor, if those
Scott, are you still there?
conditions, if those conditions are acceptable to Mr. Brandt, that they are acceptable to me. And just so that I'm clear, in the 2587 case, that's our sentencing case, along with the 4726, 4727 cases, we'll set them all over for status on September 4th. Did I get that right?
That is correct. I didn't get to that one yet, but if the victims have no objection, I'm inclined to continue
Understood.
that again for setting of the sentencing hearing on September 4th.
That's fine, Judge. I just
okay.
need the time
Now,
on September
Mr.
4th.
That was
I didn't quite
8:30.
hear that. Did you say what time? Is that what you said, Scott?
Yeah, yes,
8:30 a.m.
8:30. Okay. All right. Thank you.
Now, Mr. Poland, as far as that date is concerned, if you want to do it on your part by WebEx, I don't have a problem with that because all we're doing is setting the sentencing anyway. So if you know, you don't need to come out here and sit through a felony motions hearing just to get a new date. It's up to you.
That's fine, Judge. I will do that.
Okay. Right. Now, Mr. Kelly, anything from the more that you wanted to take up on the record?
Your Honor, other than setting the dates, the only other thing that we plan to address in the felony case was bond.
All right. Anything from the prosecution?
Judge, I know that the court had a lengthy discussion with Mr. Brandt. I just want to make sure that the court is finding a full knowing, voluntary, and intelligent waiver of the speedy on the 20 CR 358 case.
I'm finding a knowing, intelligent, voluntary waiver of speedy trial on the two misdemeanors that are set for that are as to which he's been arraigned, and the felony as to which he's been arraigned. And I'm finding a knowing, not only a knowing and intelligent waiver, but an actual request that his sentencing be postponed on the misdemeanor case that he's been convicted of. Now, counsel, there is, well, this is probably premature, but let me just let you know that assuming we go to trial on the felony case, I would assume you guys have all, Monday, the Supreme Court, our Supreme Court, state Colorado Supreme Court, the state Supreme Court came out with a juvenile case. I think it's RD. And basically, it dealt with the issue of the interplay between threats on the one hand and the First Amendment right to free speech on the other, and gave a formula basically for evaluating that. My first thought after reading that case is that is a matter that the court is supposed to continue and is supposed to consider in doing its independent First Amendment evaluation. But I would like the help of all of you, if and when we get to the motions hearing, to determine whether you think it's appropriate that there ought to be some sort of a jury instruction regarding the meaning of a true threat. I don't know that is a jury question as much as it is a constitutional question, but I think it is worthwhile that you all give me the benefit of your thoughts on that. And if anybody thinks that it's a jury question as well as a constitutional question, I'd like to have you all let me know what your thoughts are on an instruction. I think if an instruction is necessary, it's going to be pretty straightforward because I can't remember who it was. I think it might have been which one of them was the law professor? The justice. Anybody remember who wrote RD?
I can try and pull it up.
Don't worry. I think it was hard, but I'm not sure. And I think she laid it out pretty clearly, so I don't think it would be a real problem. But I would want your thoughts on that. So just have that in the back of your mind. If we end up going to motions, I want your thoughts on whether we should be preparing a jury instruction so we don't end up wasting a bunch of time in the middle of the trial talking about it. And that was pretty much everything that I had. Are you ready to report back to me?
Yes, we are. Our victims and the people are fine with setting this out till September 4th with a waiver.
All right, September 4th it is then. Now let's get to the...
Really quickly, Your Honor, I've been for the bench because I'm sure that counsel hasn't really had a chance to come up to speed on RD, but I've been following both the RC and the RT cases very closely. And it would be my contention that it is both a question of law and a question for the jury.
All right. Now, counsel, I want to get to the bond question, and Ms. Cullen, you wanted to go ahead and make argument on the request to reduce bond?
Actually, Judge, if the court would allow, I would prefer to let the prosecution go first as far as their position on any bond reduction, and then I'd like to address that if possible.
I don't care. Do you care?
Judge, it's their request. We've addressed bond previously, I believe in February. So our position is still the same.
Were you able to hear him?
Yes, I was, Judge.
if their position is they oppose a bond reduction, they think it's been heard twice, and they don't think I should give you another bite at the apple. I'm gonna at least entertain it. Whether I'll grant it or not, I'm at least gonna entertain it.
Sure. Okay, Judge. So first, the issue here is Mr. Brandt has a currently set bond in this case at $35,000 cash only. As has previously, I'm sorry.
Didn't I modify that to $35,000 cash or surety?
Judge, that's not how it appears in the court paperwork, and that's not how the jail has it listed as far as what Mr. Brandt would be able to post to get out. So,
1 second here.
It was addressed on February, I believe, 19th.
Is that when it was addressed in front of me? I'm probably wrong. My memory was that I found that the bond amount was appropriate, but I didn't see the reason it was a cash only bond.
Sorry, I think it was addressed in front of you in April. Let me go back.
Yeah. I could well be wrong about that.
I don't have anything.
Counsel, it appears that you're right. When I heard the matter in April, I didn't modify the bond. That may have just been a subjective thought on my part that I didn't know why it had to be cash only. But so I think you're dead right. It's $35,000 cash only bond.
okay, thank you, Judge. So, as I was stating, currently as it's set, the bond is $35,000 cash only. Mr. Brandt is an indigent defendant. He is unable to post a $35,000 bond. That $35,000 bond was initially set on January 28th when Mr. Brandt was arrested and taken into custody for this case currently. At that time, there was no national, state, or local guidance on any sort of health advisory regarding the COVID-19 outbreak. So when that bond was set, it was set in a pre-COVID environment. Since that bond has been set, we've experienced we continue to experience this ongoing pandemic where more than 100,000 Americans have died. Mr. Brandt is currently housed in the Jefferson County Jail, which, based on publicly available data, has a capacity around 1,300 individuals. I received information from other defense attorneys on or about May 24th that the current understanding at that point was that Jefferson County had approximately 163 individuals isolated on the 7th floor of the jail. Those individuals were people who had either symptoms, who had tested positive, or who were believed to be exposed to COVID-19. In addition to that, Mr. Brandt has been in jail that entire time. During the time of him being held in preventative detention, pre-trial on this case, he has come into contact with people who have been affirmatively diagnosed with COVID-19. Those individuals are inmates and Jefferson County staff. The issues that exist in a jail are very similar to the same type of issues that exist, for example, on a cruise ship. It's almost impossible to properly socially distance, to properly disinfect, and to put Mr. Brandt in a position where he is as free as possible from the likelihood of contracting this virus from any of the other individuals that are in there. In addition to that, Judge, Mr. Brandt has a pre-existing condition. He's asthmatic. As I believe the court is aware, COVID-19 is a respiratory disease, is a respiratory virus. The asthma that Mr. Brandt suffers from, also a respiratory disease. And the current guidance from the CDC is that individuals with asthma should be considered in a high-risk category, much like many of the other people based on age or other pre-existing conditions. So it's our assertion that not only is Mr. Brandt high risk, but that being placed in the jail facility where social distancing, proper disinfectant, and proper access to protective equipment is not available. Frankly, jails are one of the worst places to try to prevent the spread of a pandemic like this. They simply weren't designed with this in mind. And for all of the other hard work that the jail staff puts in, they're truly not qualified to, they're not qualified and they're not trained properly as staff would be in a hospital. And so Mr. Brandt is placed in a situation where not only is his health at risk because of being in jail, but his health is further put at risk because of his pre-existing condition. Your Honor, in addition to the COVID issue, I think it's important that we have to address the other concerns here, specifically with community safety, maybe even more specifically with the safety of the alleged victim in this case, and with the likelihood that Mr. Brandt would come to trial.
The likelihood that what?
The likelihood that Mr. Brandt would appear at future scheduled court dates. Now, as the court is aware, Mr. Brandt has a number of arrests on his criminal history. And I will say that although in the past I've had clients that had a number of arrests in the same ballpark as Mr. Brandt, I have never seen a client who has had as many arrest charges either dismissed outright by the district attorney's office, the city attorney's office, or the judge in a case. And I believe in a small number of cases, acquittals. Based on our review of Mr. Brandt's arrest cycles, and I believe that we did this with the criminal history that was provided in the Adams County case, Mr. Brandt has approximately 86 or 87% of his cases that were ultimately dismissed. The way that we want the court to look at those cases is we believe that those are scenarios in which Mr. Brandt engaged in some sort of an action. And if whoever joined could please mute their mic.
Wait a second, stop.
Thank you.
Somebody's doing something that's making a noise. Somebody's scraping something or rubbing their hand against something. And
Your Honor,
the last part of it you said.
Yes, Your Honor, I'll back up. I believe that was a feedback loop, and I think that microphone has been muted. Your Honor, what I was saying is we would request.
What you were saying is that most of his arrests don't result in convictions, and the nature of his philosophy is such that that's to be expected. You don't want me to consider arrests that don't result in convictions against him. And also, there are very few failures to appear, and the number of arrests, the number of failures to appear for a person with that many arrests is pretty small. I think I got that part of what you were saying, but after that, I couldn't hear the rest of it.
Your Honor, I think all of that part is accurate. Mr. Brandt, the few FTAs he has are almost exclusively attributable to situations in which he was incarcerated and not transferred on a writ. In fact, Mr. Brandt and I have joked back and forth that he appears to have a better appearance record than his attorneys throughout the years on these cases. And Your Honor,
joke. That's in fact true.
Your Honor, in addition to that, I think what is important to look at as some of the other things that have changed since the time that this bond was imposed. I believe one of the things that had been considered in prior arguments before today was that Mr. Brandt had a pending case in Denver where he was charged with a second-degree assault on an officer. That case had a bond set of $100,000 cash only. That case has since been resolved. Mr. Brandt pled that case to a Class 3 misdemeanor, harassment with obscene gestures. At that time, Mr. Brandt was sentenced to credit for time served, and that case was closed out. So the importance of that is currently, Mr. Brandt has no pending charges that have any sort of a violent nature. Mr. Brandt also has no convictions in his past, any sort of violent natures. Mr. Brandt, in this case and in other cases, has had these types of charges, these retaliation against a judge charges filed against him. But I think it's important to note that these cases are strictly done based off of words that Mr. Brandt has used typically in those cases, it's things he has said as he publicly posts on his YouTube channel. I believe the concern or some of the statements that are attributed to Mr. Brandt in this case is from the charging document. You better watch this video, Ms. Majid. Bad girl, what you gonna do when the fuck the cops guys come for you? I'm coming for you. And then, Your Honor, what I think is important to point out in that specific quote that has been attributed to Mr. Brandt in the charging document is this idea that he's quote unquote coming for you. There has been no allegation at any point that the defense has been made aware of that either Mr. Brandt or anyone acting at the urging of Mr. Brandt has actually communicated, has actually engaged in any physical attempt or physical action to demonstrate any sort of a threat to anyone. And specifically, Judge, when this last line, I'm coming for you, that has a very specific meaning when it relates to Mr. Brandt. Mr. Brandt, as the court remembers, has this large history of cases being dismissed. And the way Mr. Brandt has come for municipalities, counties, and police departments is by filing lawsuits and being successful at a number of those lawsuits. So in this context, we urge the court to view this as Mr. Brandt saying he's going to come for you in the case of a lawsuit. And Your Honor, I think that argument is even further bolstered by the actions that were taken by the Jefferson County District Attorney's Office in this case. The incident and the video that is attributed to this case took place, I believe it was on November 19th of 2019. At that point, Mr. Brandt had made that video after leaving the alleged victim's courtroom, Judge Majid in this case. When that was communicated, when the investigation started on that case, Mr. Brandt was not arrested on the 19th of November. He was not arrested later that week or later that month or even later that year. Mr. Brandt was not arrested for 70 days after these alleged statements were made. And Your Honor, the reason that we believe Mr. Brandt was not arrested is one, because nobody, the police, the alleged victim in this case, who is in a unique position, I will address that in a second, nor the district attorney's office viewed Mr. Brandt as a true credible threat to the alleged victim in this case. Had they viewed him as a true credible threat, he would have been arrested prior to 70 days after the alleged incident. What in fact happened is the district attorney chose to submit this to a grand jury to get an indictment. We believe this was done at least in part to avoid the district attorney's office of Jefferson County from ending up on the opposite side of a V from Mr. Brandt in a lawsuit. So, Your Honor, in this case, and the alleged victim in this case is in a unique position because the alleged victim is a judge. The alleged victim is very familiar with the law, not only of the state of Colorado, but is very familiar with how to contact either law enforcement in this case or the district attorney's office in this case. And I truly believe, and I don't think it's a stretch to say, if this alleged victim or the police department, the sheriff's department, or the district attorney's office truly thought that Mr. Brandt was a violent threat to the judge in this case, he would have been arrested promptly. He wasn't. He was allowed to remain out of custody for 70 days. During that 70 days, Mr. Brandt appeared at least once in the courtroom of Judge Majid while she was on the bench. He complied with the court orders. There were no incidences. He was not arrested. At that point, he was allowed to leave. During this entire 70 days, Mr. Brandt continued with his practice of publicly broadcasting himself quite often. Mr. Brandt's overall attitude towards this type of conduct and this type of speech that he engages in, he broadcasts himself. He is one of the most transparent people I have ever seen as far as his actions and where he is and what he's doing. I believe at that same time, Mr. Brandt also had a GPS monitor on. At any point, had anyone actually believed that Mr. Brandt was a true threat, he could have been arrested and taken into custody, but he wasn't, because they chose to go the route of a grand jury indictment. And Your Honor, the other point to that is this situation that Mr. Brandt finds himself in currently. This idea that every person in our country is entitled to equal protection under the law is an ideal that our country was founded on, but an ideal that has been imperfectly realized. One of the other statements that is attributed to Mr. Brandt in this charging document is, so if you don't want the violent end I'm prophesizing, then do something about it and stop acting fucking stupid. Mr. Brandt has a history of criticizing law enforcement and the judicial system for how they act. We live in a world where there are two systems of criminal justice. There's one if you're rich or powerful, and there's another one for those that aren't. If Mr. Brandt was a man of means, he would be out of custody right now. He could have posted that bond. He could have posted that shortly after he was arrested, but he's not, because he's an indigent defendant. And right now, what's happening in this country, not just in this state, not just in this jurisdiction, but all throughout this country, there are protests. There are people all over the country that are recognizing our system does not hold everyone accountable equally. These are the things that Mr. Brandt has been saying over and over and over and over again. He may not always use the best language to describe it, but the exact issues that he's been railing against for years are the issues that are prompting protests throughout this country as we speak. The world that Mr. Brandt lives in, and the world that Mr. Brandt has been complaining about and trying to not only educate people about, but I think to some degree warn the government and elected officials about, is exactly what we're seeing right now. That if nothing is done to hold people accountable, specifically in the criminal justice system, if nothing is done to hold those people accountable, at some point society says we have had enough. And then you have exactly what we're seeing in this country now. Mr. Brandt was no part of instigating any of these protests. He was not involved in this. He's been in custody since this happened. But exactly the type of thing that he said would happen if the criminal justice system continued to let police officers and elected officials and powerful people out of their responsibilities, that what he said would happen is in fact what's happening here. We don't think that is a threat. We think that is exactly what he said in here. It's a prophesizing. It's saying, look at what's happening. At some point, people are going to get tired of that. And Your Honor, that's exactly what happened. And it happened because so many members of the general public now understand that, unfortunately, this idea of equal protection is not equal. It has not been treated equal. And Mr. Brandt is an example of that right now. He's an indigent man being held on $35,000 cash-only bond. He cannot make that. He is high risk to get infected by the COVID virus that's currently out there. And he is not a threat to the alleged victim in this case. He is not a risk to not appear in this case. Your Honor, what we are asking this court to do is to set a reasonable bond for Mr. Brandt. We are not requesting a PR bond. We understand, Mr. Brandt understands, that these are serious allegations that carry a serious possible penalty. What we are requesting the court do in this case is grant Mr. Brandt a reduction from $35,000 cash only to $3,000 cash only, or in the alternative, a $20,000 cash or surety bond. Your Honor, the other thing that we acknowledge in this case, based on the seriousness of the charges, is that there may be other conditions which are appropriate in this case. One of those that we think is appropriate is a GPS monitor. Certainly, if the court thinks exclusion zones are appropriate in that case, then we would consent to those. Mr. Brandt would consent to those. The only potential challenge with an exclusion zone using GPS would be the courthouse, where the alleged victim in this case works and where Mr. Brandt will have to return multiple times. So we would ask the court to consider GPS as a reasonable condition of bond and setting Mr. Brandt's bond at either a $3,000 cash only bond or at a $20,000 cash or surety bond. Thank you, Judge.
Thank you, prosecution.
Judge, thank you. I think it is important to note, as the court did at the beginning, that this is, I believe, is the third time bond is being addressed by the court. Much of what we have heard was heard the previous two times in terms of the nature of the case, the history that Mr. Brandt has, the fact, their belief that these are just words and there's no physical violence, as well as the large number of dismissals and or acquittals. That's all. Those are all arguments that this court has already heard when it has denied the request the two previous times. So essentially, the new information, the new argument, as I see it, is twofold. One is COVID, and we can address that. And two is the other Denver case that was originally a felony, but now has since been pled to and convicted of harassment. As far as the COVID argument goes, I can tell the court that this bench has addressed similar types of requests based on the virus and the issues presented by COVID. However, as noted that the jail has put into place and attempted to minimize those risks, and the pandemic alone is not sufficient to adjust a bond that is otherwise appropriate. When we are looking at 16-4-103, and specifically the list of factors the court can look at to consider, there are some in particular that need to be pointed out. Sub F, this is 16-4-103, 5F, the likely sentence considering the nature of the offense presently charged. It's important to note, as this court has indicated earlier, he was on that deferred judgment, so he is subject to the aggravated range. Subsection H, any fact.
Is he subject to the aggravated range or the enhanced range?
Since it's I'd have to double check. Either way, it's up to the double.
The top end could be double.
Correct.
Okay.
Sub H, any facts indicating the possibility of violations of the law if the person in custody is released without certain conditions of release. Again, as the court has noted and voiced concern over in the past, the fact that he was on a deferred and is on a deferred for this exact type of behavior and conduct speaks directly to that. Any facts indicating that the defendant is likely to intimidate or harass possible witnesses. I know this court has reviewed the grand jury transcripts and the video that the defendant himself made and posted. So we do object to any modification.
All right. Anything further from the defense? I'm sorry, but this is something I hear from the lawyers on. I don't hear from the defendant on this.
Yes, Judge. The only thing that I wanted to make the court aware of, in the Adams County case, the 20 CR 19, I believe, as I stated, Mr. Brandt's bond in that case was reduced to $3,000 cash. In that case, Mr. Brandt is facing the same type of charges as he is here, but with two additional victims. And so I wanted the court to be aware of that, and the court to be aware of the precedent of other courts in close jurisdictions reducing a bond in the same range that we're requesting here.
Well, isn't he actually looking at a class 3 felony there?
Yes, Judge.
In Adams County? Okay. All right. Well, thank you all. The court is going to grant the motion in part and deny the motion in part. This may not do the defendant any good, but I'm going to reduce the bond in this case from a $35,000 cash only bond to a $10,000 cash only bond. And I'm going to make a few comments on this, although I'm not sure that they're they're really necessary. First, prosecution is dead right. This is a matter that was considered by a county judge, and it was also considered earlier by me. Now, I'll be frank. I'm sure I didn't put this on the record, but at the time, I thought I didn't think the county judge who set the bond acted inappropriately, but a $35,000 cash only bond seemed a bit unusual. In looking at the defendant's record and the circumstances, it appeared to me that there were some things that could well have justified this. One was that he was on a deferred judgment for similar conduct at the time these events allegedly occurred. A second was that he had several other cases that had arisen while he was on that deferred judgment, including a case in Denver that at least involved allegations of actual violence, a case in Adams County that involved this same sort of conduct, and the case that's before me, which, because it was a grand jury indictment, I reviewed the evidence that was presented to the grand jury. And to be candid, the evidence, at least for this particular charge, appears to be reasonably strong. I think that some of the points that defense counsel has made are valid points. First, the reality of the COVID pandemic that we are facing has a couple of wrinkles to it. One is the fact that people, particularly people with any kind of an underlying condition, or people who are old, face a very realistic prospect of losing their lives. And that's obviously very concerning to those of us who are old and all people who have an underlying condition, including Mr. Brandt. But the other aspect of it is, for people who are incarcerated, it requires a significantly increased degree of social separation. And that sort of thing is very hard on people. And frankly, my impression is that, given Mr. Brandt's personality, it's probably particularly hard on him. I think Mr. Brandt is a social person, and it's got to be difficult for him, and as it is for all of us, to be more socially isolated than usual. So I am aware that this is probably very difficult for Mr. Brandt. Regarding issues of victim safety, I think that the defense is correct that the only record of violence that I saw on his record was a circumstance that happened many, many years ago where he assaulted, I believe, his father. He has a lot of arrests, but other than the allegation in Denver, they did not tend to involve the actual application of violence. That having been said, however, both the United States Supreme Court and recently our own Supreme Court in the RD case have pointed out that threats are criminal, whether you're going to follow through with them or whether you're not, because it's the nature of the threat and the effect that the threat has upon people that constitutes the crime of a threat. And in this particular instance, it seems that the evidence that is going to be presented at trial is pretty clear. Mr. Brandt was threatening this judge in loud and emotional tones. He, as counsel said, he was saying, bad girl, what you gonna do when the fuck the bad cops guy comes for you, and then leaned into the telephone and yelled, and I'm coming for you. I think he may have even called her a name. Beyond that, however, if one looks at the threat he made rather than what he may have intended, it did not appear to be a threat to sue her, because he went on to say that he supported or in some sense was in favor of the random killing of judges and police officers, and then makes reference to a prophecy. And the prophecy appeared to be the random killing of judges and police officers. So a person who was the recipient of that threat, if they took it seriously, would believe that they had been threatened to be killed. either by Mr. Brandt, who he said was coming for the judge, or by persons who have respect for Mr. Brandt and listen to Mr. Brandt because he said he supported the random killing of judges and police officers. Thus, the threat that was made here, if viewed from the viewpoint of a victim rather than the viewpoint of Mr. Brandt's subjective intent, could be considered a very serious one. Also, there is another pending case in Adams County, which, if the facts are proven, involves similar sorts of conduct. So, there is unfortunately a history that suggests that even judicial intervention, such as a deferred judgment, does not necessarily keep Mr. Brandt from committing additional crimes. Now, having said all that, a significant factor, it seems to me, in the setting of this bond was the fact that he was, for really the first time since something like 20 years ago, actually accused of violent behavior. That case that involved the violent behavior has been pled down to a low-level misdemeanor that doesn't involve any violence at all. And it seems to me that that is significant when one takes a look at the need for a very high cash-only bond. I actually agree with defense counsel that despite Mr. Brandt's lengthy record and the significant risk that he may commit additional crimes when he is out on bond, it does not appear that he has a high likelihood of failing to appear in court. It appears to me that counsel is probably right. When he's had failures to appear on his record in the past, many of them have been explained by the fact that he was in jail somewhere else and therefore couldn't appear in the court. So it appears to me, having taken all of these matters into consideration, that the $35,000 cash-only bond is higher than is appropriate, and that is largely because one of the factors that I expect was taken into consideration by the judge that said it was the allegation that he had actually committed violence against a police officer in conformity with the various threats that he seems to regularly make. That has not been borne out by the subsequent history of that particular case. Nevertheless, because of his record, because of his propensity to commit additional crimes, and because of the potentially very serious consequences, if he's convicted in this case or convicted in the new Adams County case, it appears to me that a substantial cash-only bond is appropriate, but not in the view of this court, a $35,000 cash-only bond. So for all these reasons, the motion is granted in part, and the bond will be reduced from $35,000 cash only to $10,000 cash only. Now, regarding the GPS, I'm not sure I see a need for a GPS here. I know he's been on a GPS before, but I don't know that. Well, I will hear from you both now regarding the conditions that either side would request on this bond, but I'm not sure I understood. The reason he was ranting at Judge McGid, the reason he was ranting at Judge McGid was because of a GPS with no exclusion zone. It seems to me, I wouldn't second guess her judgment, but I don't really. If either side is requesting a GPS, I'm going to want to know why you think a GPS is appropriate here. But there are several other conditions that may be desired, and I'll be happy to consider whatever you'll have to say about them. So first, let me hear from the prosecution. What, if any, conditions are you requesting if the defendant makes this $10,000 cash only bond?
Judge, a full protection order, no contact provisions per statute. I believe GPS is already a condition of one of the pending misdemeanor cases, so assigning a double GPS doesn't achieve much. Okay. And would you like him? I think it would be inclined to order that he be excluded from the Jefferson County courthouse, except when he has business here. That would only exist so long as this case is pending, because
frankly, I think people should have the right to go to the courthouse any darn time they want. But
People
since
agree.
this is the place of employment of the victim, I would probably limit his ability to come here to a time when he has some actual business in the courthouse or in the county, in the other side of the building, motor vehicle division or something like that.
People agree. The courthouse is a public entity. People have all kinds of legitimate reasons to be here. If he has business purposes, we're not looking to preclude him from conducting his business. So, understood.
All right. Does the defense wish to be heard on what conditions, if any, you believe is it true that he has a GPS on some misdemeanor now?
Your Honor, I have a
would know.
GPS on the underlying misdemeanor case yet, which is again the only exclusion zone is the alleged victim's place of work, which is somewhere down in Cherry Creek. I've not been excluded from my home, which is literally right next door. She is the president of our housing authority, housing association. And and I've not bothered that woman. I've steered very clear of her, and for that matter, I would steer very clear of Miss McGinn too. So I don't think that the court needs to worry about that. I understand that, and I'm very well aware of the fact that the noose is actually tightening around my neck, and I don't want to kick the chair out from under it.
Defense counsel, did you have anything else to say regarding what you think are appropriate conditions if he makes this phone?
Your Honor, what I would say is, excuse me, we certainly understand the court's position regarding GPS. We understand the request for a full no contact order. All of that seems reasonable. All of those reasonings seem reasonable. I would also just like to add for the court and for the district attorney, as has been stated multiple times before, Mr. Brandt's hope and intention is to resolve these cases. We certainly expect that at some point there will be a situation where a judge, whether it's you or a judge in another jurisdiction, is faced with the decision for Mr. Brandt if he has a felony conviction, which is certainly possible, perhaps more than possible. But in that situation, we believe that a judge is going to be in the position of determining whether Department of Corrections or probation is appropriate for Mr. Brandt. Specifically with that judge, Mr. Brandt is well aware that whatever actions he takes or does not take while on bond, if he can bond out in this and the other cases, will certainly be taken into consideration by any court which is sentencing him. I think that in itself is a very powerful motivator for Mr. Brandt, and I expect that he will be able to stay in full compliance of everything, of any of the orders from this court.
All right. Well, the bond then is reduced from a $35,000 cash only bond to a $10,000 cash only bond. Condition of it is to have no contact directly or indirectly with the victim or any endorsed witness in this case, and is not to come within 100 yards of the victim's workplace, which is the Jefferson County Courthouse, except when he has business in the courthouse or in the administrative offices of the county. I don't see any reason to add a GPS here. Apparently he's on a GPS, and I'm not sure there would be and I don't see any reason to impose such an order in this case. Now,
Honor, two things, please. Can you make sure that condition specifically except for business in the building, particularly since pre-trial is in this building, and you had already mentioned Department of Motor Vehicles, and considering that there is kind of heightened security at the courthouse where people are expected to behave a little better, would you make sure that that's actually in writing on the order, please? And also, I'm aware that Adams County is also imposing a GPS, so I'll be on at least, and I have a Denver GPS as well, so I'll be on actually 3 GPSs as it is.
I think we don't have just a clerk here. We've got a supervisor from administration. She'll get the minute order and the conditions of bond right. Now, let's one other thing. Mr. Brandt, do you think that there's a realistic chance that you'll be able to make these bonds?
I've been trying to raise it. Your Honor, a lot of the conditions have changed since 6 months ago.
Well,
not just
let me just tell you the reason I'm asking.
I don't have that ability
to
raise it like I used to. And we've been trying to raise bond, and I don't know exactly where we're at, but I'm going to try.
Well, here's what I need to tell you. The lawyers that you have on these cases are lawyers that have been appointed because you're indigent. You have these lawyers now because you're in jail.
Yeah.
If you get out of jail, you need to go on the very next business day after you get out of jail. You need to go to the public defender's office and fill out an application for a public defender. Then, if I find that you're indigent, I will reappoint these very same lawyers. But you have to do an application if you're not in jail. Do you understand that?
Your Honor, I actually sued a judge over Chief Justice Directive 0404, and I doubt seriously that there's anybody in this room that knows it better than I do. So yes, I'll reapply.
Okay. We will see you all back here then for a motions hearing on the 4th of September at 8:30. Your plea cutoff date in the felony case is 8/31. And we will also reserve a, I don't usually do those. What do you call it? A trial readiness conference? So you call it 8th of September at 9 o'clock. The matter is set for trial on the 6th of October at 8 o'clock. And counsel, unless there's something else, I think we've covered what we needed to do today. Anything else from the defense?
Your Honor,
Yeah, on the misdemeanors,
There
yes.
is.
Yeah, Your Honor, as far as the
Yes, Judge.
felony case is concerned, I think we're done. But I understand that there are some issues to address on the misdemeanor cases.
All right. And then, Mr. Pullen, you wanted to address something else?
I do, Your Honor. The bonds, we've got $1,000 bond on the 2587. I think it's cash surety, and then two $5,000 bonds on the 4726 and 4727 cases. I had filed a fairly detailed motion asking the court to reduce those bonds. And to the extent, if you want me to cover what's contained in the motion, I will be happy to. It'd be a supreme irony if Mr. Brandt is able to post the bond that you just said in the felony, yet remains in custody because essentially he's got $11,000 in bond to come up with on 3 misdemeanor cases. The court heard the evidence in the 2587 case. That's the $1,000 bond. I can tell the court in the 4726 case, we have Mr. Brandt yelling at one of the Lakewood officers who reports that because of his yelling and slapping the vehicle because he was about to blow the tires on his patrol car, that we've got a $5,000 bond there. In the other case, we have Mr. Brandt engaged in a argument with the lady who runs the condominium complex. They get into a yelling match with one another, and he's charged there with harassment, obscene language, and disorderly conduct. And I would note, Judge, one of those charges is a Class 1 petty offense. In addition to that, we've got a defendant who has now served a considerable amount of county jail time. How that's going to get apportioned, I think, is ultimately going to be up to the court. But he's got a lot of time in. And now we're setting all 3 cases for early September. So we're looking at the rest of June, July, and August that he could potentially remain in custody. The data that I'm getting from the county jail, Your Honor, as it relates to COVID-19, and again, this is not a criticism of the jail whatsoever. I trust that these officers are working under extremely difficult conditions, and I won't repeat the arguments that were eloquently made by Mr. Kelland. But the fact of the matter is the number of COVID cases, based on the data that I'm getting 2 or 3 times per week, continues to rise. none of us want to see Mr. Brandt dead as a result of his incarceration. And I suspect, and I don't say this to be a smart aleck, I suspect that's true of the staff at Lakewood Police. I understand he has made their life difficult. I get that, and I think he gets that. We would agree to any reasonable condition, be it GPS monitoring, stay away from the Lakewood Police unless it's an emergency or something of that matter. But the relief that I requested in the written motion, Your Honor, I do think this is appropriate for a personal recognizance bond. This man is indigent. He does not have the resources to come up with monies to get out of jail. If he did, he would have done that some time ago. If the court is not inclined to do that, realistically, the only amount that he would be able to post would be $100 cash bond in each of the three cases, again, subject to any reasonable condition. And Your Honor, I was not aware of Mr. Brandt's, and this is my failing, not his, of his asthma condition. I did not include that in my motion. I won't repeat the argument that has already been made, but I think that medical condition places him at much greater risk of contracting this virus and the virus possibly being lethal should he contract it. He is a social guy. He and I have already talked about other inmates there that he has had concern with. It's just a bad place for someone like him to be in right now. And again, I'll end where I started. How ironic would it be that he ends up posting a bond on an F3, but is unable to post bonds on M2, M3, and a Class 1 petty offense? That would be supremely ironic. So we're asking for significant modifications, Your Honor. And I think largely COVID is a huge factor. Again, I know the jail's doing the best they can. I'm also looking at what his likely sentence is going to be in these cases. He's already served all, if not a significant amount of that time. Now we're setting it out 3 more months. I think it would be unfair to require him on our cases to remain in custody, subject to these high bonds. Thank you.
Thank you, counsel.
I'm looking at these cases, and I'm showing that he's posted his bond in all 3 of these. Mr. Brandt has posted his bond in all 3 of these.
Well, he did, but then he asked that his bonds be revoked.
Okay.
What's that? Well, what I said, as soon as Mr. Poland filed the motion, I'd revoke his bonds. Maybe that motion was never filed.
I'm not seeing anything.
The jail records that I reviewed the other day with the deputy show that these bonds are that I have to post these bonds. But we'd asked to revoke those, because I knew that I was going to be in custody for a long time, if not indefinitely at the time, and it was agreed that we do that. But those bonds have been revoked as far as the jail's concerned.
Well, I thought we did, but we're gonna double check the court records and see whether they show having been posted or not.
And Eric, could I please have you keep your voice up because I'm having a lot of trouble.
One second, please, everybody. You say it again.
Sure.
The jail paperwork indicates that he is only here on a court notification for the 3 misdemeanor cases. They are not holding him on those cases.
Counsel, maybe you all can check on this for me, but it appears to us that both the court records and from what we understand, the jail records indicate that he's made the bonds on the misdemeanors. Now, it is true that I told him I would revoke them. We had I don't know why we had a conference. I think it was just we had some sort of a hearing on the felony only, and Mr. Poland didn't participate because his case wasn't involved. Mr. Brandt asked me to revoke his bonds. I said I would do it if, but only if I got a motion from defense counsel. I'm not sure we ever saw that motion, and the result is we never actually did it. So the bottom line is he's on bond on the misdemeanor cases, and I don't see any reason to take another look at it.
If that is the case in the record, then I certainly would rather not have to come up with that money to post again. I would appreciate that.
Well, Mr. Poland, if it
Sounds like Judge, we're going to leave it alone, Dan.
Okay. All right.
There's no motion to revoke the bond.
Yeah, there was, see, we never got the motion to revoke the bond, so I never actually revoked them. And it looks like he's made those bonds. So now, honestly, I don't know. Did he make the $1,000 bond on the one he was convicted of?
He's posted on all three, yes.
Yeah, he's posted on all three. So there's no need to take up bond on the misdemeanor cases. Now,
Your Honor,
Mr.
can we
Bowen,
ask
was
the
there
clerk to send that paperwork over to the jail with the CR bond information, just to make sure that their record is correct? Because the jail seems to show.
we have a sheriff right here in the courthouse who's already taken a note to check on it. So
Okay, thank you.
We're in front of you on that.
Marvelous.
All right. Anything else, Mr. Poland, on the misdemeanor cases you wanted to bring to my attention?
Your Honor, it sounds like the issue of bond has been taken care of satisfactorily, so we'll leave it alone.
We will see you all back here then on the 4th of September at 8:30. Thank you,
Judge.
Thank you, everybody.
Thank you, Your Honor.